questo combino sempre due. Un due con
Have personalized much of them. Leading to the honorable the convenience of the proceedings, the council seeks permission to address honorable members of the tribunal individually as honorable members and collectively as the bench. Much obliged. My co-counsel and I are representing the applicants Alpha, Beta, Gamma, Delta, and Epsilon in an appeal against the Commission's order from 10th of January 2025 under Section 53B of the Indian Competition Act. There are three issues before the Honorable Tribunal pertaining to the same. Under Issue 1, the appellants challenge the Commission's allegations of an anti-competitive agreement under Section 3 of the Act against all five companies. I shall be addressing Issue 1 and shall speak for 18 minutes. My co-counsel shall be addressing Issues 2 and 3 and shall speak for 25 minutes, reserved 2 minutes for rebuttals. If there are no preliminary inquiries and if the Honorable Bench is well versed with the facts at hand, may the Council proceed with their submissions.
So you know the usual court practice, because initially the facts has to be narrated before the bench. But now since we were already briefed, so I'm just asking, were you people aware about the court procedure actually happening? Because Moot court, you are copying this, so you should be knowing that initially facts has to be narrated before the bench and then the issues will be framed, and on the basis of those issues, you have to answer accordingly. So you are well versed with all this? Yes, yeah, please.
A narration of the distinct facts at hand. The council's in keeping in mind the paucity of time, sought to ask if the bench is well versed with the facts and if they are, the council would like to see this stuff. Much obliged. The council shall dispute the allegations by the Commission finding applicants guilty of an anti-competitive proceeding under Section 3 of the Act on three primary prongs. The first being that there is no agreement between the applicants. Second being that their actions do not fall under Section 3, subsection 3 of the Act. And the third being that their actions do not cause appreciable adverse effect on competition in the market.
So before you start, could you give us the contours of our jurisdiction in the appellate space? So what is it that we can do? What is it that we cannot do?
Indeed, Honourable Member, under Section 53B of the Indian Competition Act, the Honourable Appellate Tribunal can modify or agree or disagree with the Commission's order finding the applicants guilty of anti-competitive conduct. The Honourable Competition Appellate Tribunal can also modify the penalties. 53B of the Indian Competition Act also specifies the time limit within which such an appeal has to be filed, which is 60 days, adhered by the applicants in the present case. May the council proceed with their submissions under the first prong. Much obliged to Honourable Member. Addressing the first prong of argumentation, the council shall challenge the very foundation of the Commission's order, the existence of an agreement between the companies on two limbs. The first limb being that of intent.
What is agreement as per the Competition Act?
Thank you for your question, Honourable Member. According to Section 2B of the Indian Competition Act, and the meaning of an agreement has been wide to include any action in written or oral showing concurrence of mind and intent to form an agreement, but within Section 2B of the Competition.
So can on unenforceable agreement or contract, CCI can look into those aspects, which is not enforceable by law.
Honourable Member, as correctly pointed out by the Honourable Member, the agreement, the definition of an agreement under the Competition Act is broad enough to include an enforceable contract or an action not explicitly, that an action that is explicitly written or submitted orally. Any form of throughout their decisions by the Competition Appellate Tribunal as well as the Competition Commission of India, they have broadened the definition of agreement to include any signal signs as
I think, I'm so sorry. I think the question is if the agreement is per se unenforceable, let me take that a step forward to say it is void. And is the Competition Commission even empowered to look at it because it doesn't exist right in the eye of law?
Thank you for the question, Honorable Member. The agreement need not be enforceable by legal proceedings to fall under the applicable section.
That's all we do. Proceed.
Much of it. To assess the first limb of intent, it is submitted that it is widely accepted that an agreement requires the concurrence of wills in the absence of any direct evidence established through intent. This has been established and can be found on relevant pages of the compendium, particularly flag 16, which mentions the GSK Pharmaceuticals Limited versus Competition Commission of India. If I may redirect Honorable Bench's attention to page 15, annexure 2 of the Moot proposition.
Yes.
But there is a evidence against you that there was a DG raid happened, substantive evidence found against you. How can you say that there is no case has been made out against you by the CCI while imposing penalty?
Thank you for the question, Honorable Member. Council is merely trying to establish through the submission is that the pieces of evidence found by the DG during their raid lacks is a case of circumstantial evidence that has been taken out of context. The same shall be established.
What is circumstantial evidence? What is the difference between direct and circumstantial evidence?
Direct evidence, Honorable Member, if I may explain by giving an example, would be an agreement between the companies that directly discusses their plan of action, for example, to fix prices for the coming market, for the coming years in the market. An example of a circumstantial evidence would be various different pieces of evidence, various different forms of communication.
Let's continue.
Much obliged. In the on page 15, annexure 2 of the Moot proposition, right from the first paragraph, it is evident that the North Zone plan is a result of discussions with all stakeholders, including the government, to benefit Inca's meat production and distribution. Honorable members, it is not an agreement to monopolize power. It does lack intention to collude, proving to be a case of circumstantial evidence being taken out of context. Moving forth to the second limb of argumentation under this clause, before a conclusion of concerted practice is drawn, it is important to see if parallel behavior has led to abnormal or unnatural market conditions. This has been reiterated in Rajasthan gas cylinders while citing the case of Imperial Chemical Industries was coming from European Community. Honorable members, mere parallel conduct thus does not amount to an agreement. There are two market conditions at play here, one of an oligopoly and the other of an oligopsony. If I may redirect the bench's attention to page number 2, paragraph 6 and 7 of the written submissions. If the bench is with the
That's it. Proceed.
much obliged, Honorable members, in a situation of an oligopoly, arises when products are substitutes and the relevant geographical market spans the entire country. May the council present a small illustration to show how this occurs. Honorable members, if there are two leather manufacturers on two corners of the street, these leather manufacturers are making products that are substitutes of each other, and they have the same geographical market. In this scenario, any pricing decision taken by one of the leather manufacturers shall inherently affect the pricing decision of the other leather manufacturer. Both of these manufacturers will be aware of each other's pricing strategies, as any change would lead to a significant loss of consumers.
So, sorry, isn't that when one leads the market and the other follows? If both of them are having a conversation or there is evidence to suggest that they are actually talking to each other or are aware pre-market, is that not enough?
Honorable member, thank you for that pertinent observation. In an oligopoly, however, I, as a market manufacturer who is producing goods that are substitutable to my competitor, will be aware through my business strategic decisions to ensure that I do not lose customers due to any pricing taken by my competitor. I am inherently aware of their actions. This has been seen through multiple and can be showcased through multiple OECD market reports, specifically one from 1993.
There are 5 minutes.
Indeed,
A span of 5 minutes
Indeed,
following a meeting. Why is that not circumstantial evidence? Are you dealing with an extra two before dealing with an extra one?
Honorable member, if I may answer that question by presenting the scenario of a group boycott, as has also been alleged in the written submission of the respondent. A group boycott is a scenario where,
Answer the question, counsel. Answer my question.
indeed,
Let's deal with that answer.
Honorable member, the two reasons cited by the applicants as a part of their independent business strategic decisions in those emails do stand as firstly agreeing to sell their products at rates below the prevailing market rate would significantly cause a business loss to the applicants, as they would be forced to then lower the rates for their other retailers as well. In order to maintain relations with their retailers and suppliers, they've taken this independent business decision.
Independent of even 5 minutes of each other.
Honorable member, all 5 applicants were contacted with the exact same proposal at the same time. They were given the same time duration to revert back to the email, that is of a day, as can be seen in the Moot
It is a long time, counsel. They had a day after the meeting. They responded within 5 minutes of each other with the same reasoning.
And chances are, if you check the IP addresses, they'll probably emanate from the same space.
Honorable members, while the prop is silent on the IP addresses of the applicant companies, it is pertinent to see that the language used by the applicant companies is practiced professional language, citing the reasons for rejecting their offer, which the applicants rejected only after multiple rounds of negotiation and CAPA's uncompromising insistence on buying their products at below retail rates.
After you getting their institution wrong, they are willing to subsidize for the cost. They are willing to take the product from your warehouse and to take the entire supply chain logistics in exchange for you reducing the price.
Like they're effectively leaving you to save a lot in terms of just your cost. They're taking over half your marketing.
Honorable, as a pertinent observation, this remains an independent decision, as firstly, the 5 manufacturers are the 5 major manufacturers of frozen meat in the market. As has been evidenced by the description in the second paragraph of the Moot proposition, they have state-of-the-art manufacturing facilities. Whether they want to abide or whether they want to agree to the logistical concessions offered by CAPA is a simple business decision taken by the applicants. The decision of the applicants does not restrict CAPA from approaching the other 52% of the market players in this economy. As has been evidenced in the Moot proposition, the southern state of Desto is also a very important player in the present economy.
So you're arguing monopoly or obscenity on one stage, and then you're asking them to reach out to the other 52.
Indeed, honorable member, as despite the fact that there are 5 major players, the 2 conditions establish that the products are substitutable and that their relevant geographical market spans the geography of the country, it is an undeniable fact that there do exist the other 52%, my apologies, 52% of the players that CAPA could approach.
You cited a judgment which is Rajasthan surrender. Does that not say circumstantial evidence?
It does, honorable member. However, Rajasthan senators, as correctly pointed out, also helped overturn the commission's decision, asking the commission to critically look the circumstantial evidence, the plus factors, which include prevailing market conditions, before alleging any such gross violations under the Act. As the honorable member has correctly pointed out about the case of Rajasthan gas cylinders, the council seeks to address 4 factors that were listed. 1 was the prevailing market condition. 2nd was the aspect of constant need. 3rd was the small number of suppliers. And 4th was few or no substitutes. In the present scenario, the prevalent market conditions of an oligopoly, as established by the council, and that of an oligopoly, which means that the decisions of the applicants are significantly influenced by the buyers, leads to natural conditions of parallel conduct in the market. With respect to aspect of constant need, frozen meat is not the only product available to fulfill the requirement of protein malnourishment. In fact, there are multiple government initiatives at the grassroots level, especially related to animal husbandry.
The government's not a party to this case.
That shouldn't be.
Honorable member, the order has been filed against the 5 appellants. So in the present,
But I'm asking you if according to you, the government is a necessary party, because then that's your first argument. Because your document at Annexure 2 seems to suggest that that document has the blessings of the government. It was prepared in consultation with them. The government is not exempt unless it's in the exercise of sovereign function. So why aren't you arguing necessary party? So we should be allowed only on that fact.
And do you have any idea about the sovereignty and non-sovereignty, the function in law of tort? What is that?
If I may address first question posed by the honorable member as to why the government is not a party, why the government should not be a.
Because my question will directly answer his question. What is that sovereignty we are talking about? First, let us, because you know the concept of competition law, it exempts sovereign functions. So what is that sovereign, non-sovereign? You have any case laws in your mind to suggest us? If you know, say yes. If you don't know, say no. There is no difficulty.
Honorable members, the council would like to seek their, would like to clarify their position with respect to government being a party to the present case. What the council was merely trying to establish while establishing intent of the parties was that this North Zone plan has been prepared to aid the government through their multiple strategic decisions to, in fact, regulate such a highly oligopolistic market. Regulation has been held to be that of a means of last resort to ensure that anti-competitive conduct does not happen in such a market. And that is merely what the applicants are trying to do in the present case. So,
Therefore, is it your suggestion that because it aids efficiency and takes forward a governmental initiative, and B has, in a sense, an overarching visibility to the government, therefore you are within the confines of the framework of law?
Honorable member, assuming but not admitting that the actions of the appellants did cause an appreciable adverse effect on competition, even though they were under the aegis of the government or through their independent business decisions, this would constitute a violation of the Act. However, the actions of the appellants do not cause an appreciable adverse effect on competition, which the council shall address in the subsequent prong of argumentation. But if the honorable bench seeks, my apologies, if the honorable bench wants the council to address it first, the council should do so. Much obliged, Honorable.
Be mindful of your time.
Indeed, honorable members. Honorable members, may I seek an extension of 2 minutes and may I summarize the AEC argument? Much obliged, honorable.
First and foremost, you answer this. This is an appeal, right? What are the grounds of your appeal? Number one, what are the issues framed? If you go to page 8, the propositions, 3 issues are framed. What are the findings of these 3 issues? As far as the DG's findings are concerned, it's very cryptic. You have not made any grounds for appeal. You have to argue on law. You are just arguing on facts. You are arguing under appeal. So what you have to answer, what you have to question is how the order is bad in law, what are the grounds raised, and what is the law as on date. Whether this order suffers from infirmity. These are the 4 grounds you have to. You are just, I'm just making observations. This is only to improve your the way you have to conduct in court. This is what the court asks you, not on the facts.
Just adding to what his lordship has said, the first question I asked you, threshold, is the threshold perversity? Because if it's a plausible view, then should an appellate court interfere? Do you have to take it to the level that the CCI's order is untenable in any form? And then what are the grounds?
Indeed, honorable member. If I may answer both the questions collectively as to establish how this commission has taken a position apart from the established law. The established law requires significantly higher threshold in the present scenario to such gross violation as has been established in the case of Rajasthan Gas Cylinders versus the Union of India. Additionally,
What was that case?
honorable member, in that case, gas cylinder manufacturers were alleged of anti-competitive agreement under Section 3, Subsection 3 of the Act. The Commission found them guilty. However, upon appeal and finally at the Supreme Court decided that the Commission has to consider multiple aspects, including market conditions, the two market conditions presented by the applicant in their submissions, as well as other 3 factors that the applicant listed out in their previous prong of argument. If I may proceed, in the entire in 2022, while overturning CCI's decision in the tire cartel case, also held the promotion of domestic industry is an object of the Competition Act, and the Commission has to be mindful of the effects such an industry shall create, which brings the counsel for the appellants to address how this does not cause an appreciable adverse effect on competition in market and in fact benefits the consumers. I apologize.
So the tire cartel case had a COVID related issue.
Or
Then to look at the industry, then it from the standpoint of COVID.
indeed, honorable member, from the standpoint of COVID as well
This
as
conduct that we are talking about is in 2023 to 25, irrelevant to COVID. So then how is the tire cartel case relevant?
honorable member, two factors are considered in the tire cartel case. One, as correctly pointed out, that is COVID, and the second of a domestic industry and the need to boost a domestic industry. In the present scenario, the council is merely trying to show the importance of such an industry as is evidenced by the first paragraph of the Rebuttal. Which brings me to my first submission under the argument for AEC. The council apologizes for exceeding their time and seeks an extension of 2 minutes to wrap this up. Much obliged, honorable. Honorable members, the actions of the appellants do not create barriers to new entrants, as that would entail negotiating prices with existing players and information exchange that limits access to the available information that has been exchanged. If I may redirect your attention to second paragraph of the Moot proposition, first line, from recognizing the urgent need. It can be seen, honorable members, that government promotes development of this market through targeted initiatives such as investment in livestock rearing, the establishment of modern meat processing units, and aggressive campaigns. There is an inherent support from the government for this industry, thereby lowering the existing barriers. Additionally, the appellants have not fixed prices, and so there is no question of negotiating prices with previous players. Furthermore, the impugned information exchange in the form of the North Zone Plan is an outcome of strategic discussion with the government and all stakeholders. It isn't data that is exclusively available for the applicant. Thus, it does not drive out existing competitors by putting them in disadvantageous positions either. This is beneficial to the consumer, and the council should wrap this up in 30 seconds by establishing three forms of info sharing. The three forms of info sharing are: one, R&D collaboration; second, as a part of price fixing or market sharing agreement; and third, as a standalone practice. In the present case, the information shared is in the form of an R&D collaboration to assist the government to promote such an important industry for the country. Thus, such an information exchange is not anti-competitive in nature, thereby benefiting the ultimate consumer.
You are aware of the cement cartel case?
Indeed, honorable.
Is there, and which has been applied by the tribes and it's like that if it is at the behest of the government, it does not take the action itself.
Indeed, honorable member. As correctly pointed out by the honorable member of the tribunal, that has been the provision in the cement cartel case. However, in the cement cartel case, the companies were found to cause an appreciable adverse effect on competition in the market, along with the fact that their behavior was upheld under Section 3, Subsection 3 of the Competition Act.
Why need to go to 3.3? 3 is good enough, right? This demonstrates agreement. Why would you discuss projected prices? I can understand a collaborative report which says these are the existing prices and we are giving you that information. It is essentially collaborative. When you discuss projected prices, then there is an agreement here.
Honorable members, to answer that question in two ways. Firstly, that whether this agreement falls under 3.1, indeed the honorable member can go to 3.1 without looking at the agreement falling under 3.3. However, 3.1 requires the effects of this agreement to be tested under the angle of Section 19, Subclause 3, which is a balancing test, and as has been established by the counsel for the appellants, that it does not cause an appreciable adverse effect on competition in the market. To ask the second thing,
Is it capable of being causing a appreciable adverse effect, likely to cause that?
it would have been capable of causing an appreciable. That's right. If the honorable members would be kind enough to.
Yes, 50 and 50. It seems that there is a solution. That we want some evidence when the form we made. We have to.
May the council call
Yes.
this also.
Yes.
Should you approach the dice?
So this is 10. Last 10, last 10. This is 2022. This is 10. 10.
Yes. So you heard the question. Are you prepared to answer on that? Appeal. You're arguing appeal. Make out grounds, then go into facts.
Transfer the appeal have some issues. Issue 2 pertains to the applicants contending that there does not exist a separate anti-competitive agreement between Alpha and Gamma in the instant case. And the third issue, under the issue, the applicants contend that the proposed exchange of information under the term sheet does not amount to a violation of the provisions of the competition. If the honorable member can make the council proceed. Much obliged. Honorable members, the council seeks to request the tribunal to allow the council to delineate the facts that are pertinent to issues 2 and 3. Much obliged. Honorable members, Alpha and Gamma were engaged in acquisition talks since April 2020, with the notional date for completion of such a transaction being May 2025. During a DG and supplies inspection, a term sheet was found outlining specific clauses. Consequently, both companies participated in due diligence as well as strategic integration processes, including the exchange of information on the merchant products, both well within the bounds of such a compliance. The acquisition is a combination under Section 5D of the Act, however, it has not been notified yet. Honorable members, now that the council has also delegated the issues present.
Are you aware about one judgment given by the Supreme Court recently in the context of interpretation of Section 29 and the interplay between IBC and CCI?
Honorable member, the council is aware of the interplay between the CCI.
My question is very straight. Are you aware about some recent Supreme Court judgment on this of interpretation of Section 29 of Competition Act, as well as the interplay between IBC and Competition Commission? Just are you aware or not? Just perfect.
May the council proceed?
Don't make it independent tribunal.
But he celebrated
State independence.
Under issue 2, the council shall seek to highlight how the evidence taken into consideration is the term sheet, the API correspondence, as well as the structures that are in possession of Alpha, the gas structures that are in possession of Alpha, and under issue 3, the council shall limit the same to the proposed exchange of information under the term sheet as stipulated in the issues carved out before the appellate tribunal. Further, the definition of issues is clearly the council solutions and the issue. Much obliged. Under issue 2, the council seeks to highlight how the agreement is not independent from the section 3 of the Act. Honorable members, it is not the intention of the council that there does not exist an agreement between Alpha and Gamma. There does exist one. However, it is not anti-competitive on the following 3 grounds of violation. Firstly, there is no violation of section 3.1. Secondly, there is no violation of section 3.3. These two then shall be argued concomitantly. And thirdly, there is no appreciable adverse effect of competition that is caused or likely to be caused. The council shall proceed with the first line of argument. There is no violation of section 3.1 of the Act, and the same shall be established using the third limb as a threshold for a violation of section 3.1.
It's always compulsory for the commission to take the limb of section 3.1 while establishing section 3.3, or can independently 3.1 be invoked for imposing any penalty? Any case law on this?
Indeed, honorable member, section 3.1 does not require 3.3 and 3.4 to be read, although the Respondent Commission's decision and practices are not fully consistent in this regard. In the case of LH Hiran and Rani Hospital, it was held that.
Stop. Continue.
May the council clarify.
Perfect.
Proceed.
Pleasure. While the council is aware of the Congress decision,
51 can be looked at independently, and therefore the Council seeks to highlight how both of these provisions are not applicable. The threshold for the same is an application for the cause of equitable competition, which shall be subsequently established by the Council that it is neither cause nor is likely to be caused. Moving
Why
on,
don't you address the likely to be caused argument?
Honorable Member, with the Honorable Appellate Tribunal being pleased to hear the EC argument first. Much obliged. Honorable Members, the Council, in order to support the AEC argument, would seek to redirect the Honorable Bench to flag 27 of the compendium.
Tell us what.
Indeed, Honorable Members. Flag 27 of the compendium to the proposed pertains to the efficiency gains as well as in issues pro-competitive in nature. If the members Honorable Members, this is the European Union's horizontal cooperation guidelines, which have been asserted as well as recognized by the Supreme Court of India in the case of Rajasthan Cylinders. The Council shall proceed with
What was
establishing.
the bench composition in Rajasthan Cylinders?
Honorable Members, two judgments.
You know who the judges are?
Honorable Member, Council is aware of one particular judge, Justice.
Does it matter?
It does.
Proceed.
Much obliged. Moving on to the AEC argument, the Council shall seek to establish the same on the following four lines of argumentation. Firstly, that there are no barriers to entry created by such an agreement. Secondly, it improves the production of goods. Thirdly, it promotes development. And finally, it benefits consumers. Addressing the
How
first-
consumer can be benefited when there is a clear cartelization, when price symmetry in such close quarter you are giving the rates? So how consumers are getting benefited? First, tell us.
Indeed, Honorable Member. The Council shall simply do the same by giving an example of the FMCG sector where the current parties, Appellants 1 and 3 are operating. In the FMCG sector, the market structure is such that there are low switching costs. The products are homogeneous, and the market structure is such that the prevailing form of competition remains to be price competition. And the Council shall seek to highlight how it benefits consumers since the efficiencies generated from such information exchange, as evidenced under the flag that the Council redirected the Honorable Appellate Tribunal to. Such efficiency gains are likely to pass on to consumers, as firms shall compete on the basis of price. Since efficiency gains would result in a decrease in the cost of production, that would enable the companies to reduce prices.
You're not allowing that concept by exchanging the information today without the Commission's approval. You're not even allowing the Commission to test whether or not the transaction is anti-competitive or not. The fact that you may subsequently decrease price cannot be an argument today when you are already acting as if the transaction has gone through without CCI approval.
Honorable Member, the Council understands the concerns, and the Council believes that Honorable Members in violation of the conjunctive provisions with respect to Section 6. The Council shall be delineating how this particular agreement does not amount to substantive, nor procedural gun violation.
Why
Conjunctive
not?
provision.
There is no, why not?
Certainly, Honorable Members. While this could have been done,
But why don't you just tell us? I mean, we know it could be better with something.
Certainly, Honorable Members. The Council seeks to redirect the Honorable Appellate Tribunal, page 18 of the written submissions, particularly page 69 and 70, paragraph 69 and 70.
Tell us what.
There are two forms of conjunctive violations versus procedures. In the instant case, Honorable Members, section 62 and 62A of the Act clearly stipulate that the notification is to be done anytime after the execution of a binding document for acquisition or 150 days before such an acquisition policy. In the instant case, placing reliance on the written submissions to accompany the Council's board submissions, May 2025 is merely a notional date, as firstly the merger has not been closed yet, and secondly there is no evidence pertaining to the fact that May 2025 is a final date of consummation. Therefore,
But your term sheet, for all practical purposes, evidences the contours of the agreement and you're already acting in furtherance thereof. Why should we treat this as a non-consummated transaction?
Honorable believes that that is a reference to the substantive aspect of gun jumping, shall be dealt with immediately after this argument. However, addressing the procedural aspect for further clarity before this Honorable Appellate Tribunal, it does not amount to substantive gun jumping, as May 2025 is merely a notional date.
That we understood, Council, answer the question.
Indeed,
Substantive violation.
Honorable Members. In order to establish a substantive gun jumping violation, there are three tests to be taken into account as have been laid down in the Bharti Airtel case as well as the Hindustan. The first test pertains to the test of infringement on the ordinary course of the target's activities. Honorable members, of the instant case, Alpha may solely provide inputs to Gamma on decisions related to pricing strategies and allocation. In the instant case, these are merely inputs. These are not binding, and furthermore, Alpha.
You're not necessarily the one who's buying and counsel.
And second, when would such documents be binding? Like, what would you look at to figure out if it's binding?
Honorable member, may the council address this question first. Attention. Honorable member, the binding aspect pertains not to the document, but to the rights that are given to the acquirer. The council seeks to place reliance in the case of August versus Portugal, wherein in that particular case, such an interim covenant between parties entering into an acquisition was held to be anti-competitive solely in the context of the acquirer possessing veto powers over the target's business decisions. In the instant case, that is not commensurate with the factual matrix here.
So there is no control according to you in the head.
Honorable member, there is no infringement on the ordinary course. May the council address the next question? Much obliged. Honorable members, this hinges on the likelihood aspect, and currently Alpha and Gamma remain independent competitors, and furthermore, even in the correspondence that has ensued between Alpha and Gamma, as evidenced under an extra 3 of the Moot proposition, we may refer to how both parties are currently at equal footing with respect to navigating such a transaction, and therefore there is nothing indicating that Alpha is in a position to exercise such power over Gamma.
Party is acquiring the other.
Indeed.
Is the independence there too, that's left after that?
Honorable member, that
Are you telling me that somebody is paying crores of money to acquire a company? You would direct you to do something and you would not do it?
apologies for cutting off the previous instance. However, while the council understands the possible practical realities of such infringement, honorable members, this continues to remain Gamma's independent decision to accept such inputs or not. The council seeks to highlight how these inputs remain non-binding in nature. The council is indifferent to the parties' binding or non-binding nature, but these inputs remain binding on Gamma's day-to-day operational.
In the ordinary course, would you comprehend any such directives by a competitor?
Honorable member, may the
Yes or no? It's a simple thing. In the ordinary course, would a competitor direct how you do business?
No, honorable member. However, in the instant case, they are engaging in a combination and they're entering into a combination, of course, subject to the approval of the.
That transaction is necessarily at arm's length.
Indeed, that enables the council to move on to the second test that establishes how there is no substantive gun violation. This shall be argued in 2 layers. Firstly, that it's unlikely to reduce competition intensity between Alpha and Gamma. And in the instant case, it is unlikely to as Gamma still remains an independent competitor and such inputs are non-binding and it does not affect on the ordinary course of activities in the context of such an acquisition. Addressing the second layer of this limb honorable members, it is unlikely to distort competition practices and the council is meant to establish the same through the appreciable and percent on competition being
But
unlikely.
there is no AEC test insofar as gun jumping is concerned. Are you arguing it?
Honorable member, by observation, in the identity and gene case considering the use of factual metrics, the council, the commission held that gun jumping violations with respect to such interim covenants would be assessed on the basis of Section 9 of the factors under Section 9.
That's from a penalty perspective. But the fact that a substantive violation has taken place is agnostic of whether in fact there is AEC or not. It's a simple notify, otherwise face consequences.
Honorable member, the council seeks to clarify the existing position of law pertaining to the same. It is not a simplistic version of notify or face consequences as the substantive gun jumping violation aspect has evolved through jurisprudence as well as the Honorable Respondent Commission's decision practices, therefore implying that any action that has the effect of consummating such a transaction would also mark a violation of the statutory obligations under the section 62 and 62A of the Act, and that enables the to raise another contention with respect to the appellants and the appeal present for the honorable appellate. The issue of gun jumping in itself cannot be heard before this honorable appellate tribunal, as the order is under section 27 of the Act. The council seeks to redirect the honorable members to the proposition. If the council may have a second, then point the exact paragraph. Honorable member, this is paragraph 15 of the proposition, which clearly stipulates that this is section 27, and the respondent commission in their written sections have alleged violations of section 43 of section 62A of the Act, as well as imposition of penalties under section 43A of the Act, which are to be read informally. However, additional issues and additional violations cannot be raised before the honorable appellate.
The Adani precedent that you cite.
Certainly.
What's in the Adani precedent and it says that you need to do an AEC test for all.
Indeed, honorable. Council may have a minute to close the pending.
If somebody is checking the time,
Yeah.
how much time? Okay.
Honorable member, council is not currently the council seeks to highlight how that was the established position.
That's not the established.
Honorable member, the council understands the concerns.
You can show it was in the rebuttal if you take more time. But I need the exact paragraph where it says that AEC is the test for contempt.
Certainly, addressing the next form of argumentation, since the AC as a threshold would be addressed in the rebuttal. The defense of a legitimate business transaction does apply in the instant case, as the inherence and proportionality test has been laid down with the air as well as the adaptive case, wherein in case the exchange of information is inherent as well as proportional to the objective of preserving target's valuation, then it shall be permissible, since interim covenants are permissible in the sense of combination regulation of the members. And in the instant case, it is inherent as such information is necessary to be exchanged in order to preserve the valuations. The council has highlighted how the structure of the current market where the applicants are operating is pertinent to preserving the valuation of the target company. Secondly, it is proportionate as it is limited solely to such information that would be required for such purposes. The council once again seeks to place a line Audis was a structural case, wherein the acquiring company exceeded the proportionality limit by
Precedent is that.
The competition regime, the council seeks to answer this in 2 layers. Firstly, the competition regime of the Indian government, which is superior to that of the Indian Commission, is heavily influenced by mature regimes such as the European Union as well as the American
It's
jurisdiction.
binding rules. The simple question.
It is not binding, however. The competition regime hinges on economic application as well as business consideration in the light of the objectives of competition. Therefore, European Commission do have some sort of value at assessing.
Has the commission adopted European precedent in its or is these products?
Indian honorable member.
Very products.
Honorable member, the defense of a legitimate business transaction does apply. The council has already addressed the evidence for such an argument, and the second one is proportionality. The exchange of information was limited solely to what was required for the purpose of preserving Gamma's valuation. The council once again seeks to highlight the case of notice was possible. Such proportionality was exceeded since the acquirers sought to exercise veto powers over the target company's appointment of business personnel as well as key strategic management. That is nothing of the sort has taken place in the instant case, and therefore this proportion is limited to what is required to preserve the violation. Finally, honorable members, substantial evidence is taken up with context. The mere exchange of information was not violated the act established in the case of the flashlight cartel, as well as the case of Ruchi Soya. And furthermore, things cannot be based on mere conjecture.
So just wondering why this was just in the ordinary course of business. Why do those documents have a stamp that says to be shredded?
Indeed, honorable member, to be shredded aspect is common in acquisition. It's common in many business practice, as companies frequently do shred documents that are not necessary, and there's nothing in the fact sheet that indicates that this was a sole copy of the document that was in place, and therefore does not amount to violation of any provision of the Act, since there's nothing that indicates that the parties, appellants 1 and 3, were destroying evidence, as it is not the sole evidence.
Honorable
Honorable member,
You are assuming that this was not one copy.
indeed.
And why do you mark it to be shredded?
Honorable members, ordinary in business practices to shred documents, and
Then mark every document as to be shredded. If it is ordinary to shred document,
Then
then
we have a
mark it.
policy, all documents in excess of 3 years old, we will shred, we will destroy, we will not keep copies.
indeed, honorable member, the council seeks to highlight this does not reflect a manifold intention on the
And what is
parts.
Mr. Navarro doing in that mix? Isn't his participation itself reflective of the fact that there is clearly an intent to share price sensitive information under the garb of this acquisition conversation? He should never have been part of the mix at all.
Certainly, honorable member, may the council address the honorable member, if the parties even intended to cover any such evidence in their acquisitions, then they would have also deleted other communication evidence pertaining to the same in the form of Annex 3 of the Moot proposition, which clearly stipulates that they are planning to enter into a transaction as well as collaborate. However, that did not take place in the instant case, and therefore does not reflect any malified intention on the part of appellants 1 and 3, since the email corroborates the term sheet. Addressing honorable members' second question now, Mr. Nemo Navarro's involvement in such due diligence as well as strategic business integration practices is inherent to the objective of preserving Gamma's valuation, as Mr. Nemo Navarro is in fact an executive. If any other executive were to undertake such exchange of information, it would not meet the ends of preserving Gamma's business valuation. Therefore, that would make the very object of such an agreement redundant. Therefore, honorable members, this is not a substantive violation of gun jumping. May the council establish the AAC if the honorable members have.
Right. So,
Yes.
getting them there. Third question.
See, just take this data, page 16. You see all the 5 companies, they are going in same price. Even the project, how do you explain this? Don't you think this is not enough to say that there is a cartel? How can there be slight difference of 1 or 2 rupees?
Indeed, honorable member, the council understands their concerns. If the council may clarify one aspect on the time. First, if that's possible.
Just on this point or just on this point?
Certainly, honorable member. Honorable member, is no existing in the instant case, since the market structure as is being established by the co-council is such that it is oligopolistic, as all of the parties will necessarily have similar production costs as they all operate in a similar geographical region. Furthermore, honorable members, since they operate in a similar geographical region and they produce similar goods, then it is highly likely that the costs will be the same. Furthermore, this is an oligopolistic structure where parties naturally and inevitably do respond to price variations among different competitors. Therefore, such price parallelism alone does not constitute a violation of.
Don't you think that all of them have come to the same understanding on cost and price? If you say that they are geographically located in same place, so they all are having formed an association and controlling the prices and costs. How can that be possibility? Somebody might have started a factory 10 years back. His cost would come down eventually.
Indeed, honorable.
But here, looking at the data, all are in the similar lines, like hardly there is a difference.
Indeed, Honorable Member.
This is the evidence. You have to argue on this evidence.
May the council proceed?
Another 2 minutes.
Sir, much obliged and apologies for cutting. Once again seeks to highlight how such price parallelism alone does not constitute a violation of the Act, as this is ordinary in such markets. If the council may give another example in the FMCG sector, when it comes to biscuit prices, especially biscuits that follow a similar taste or a similar mood, they all range in similar prices regardless of what their costs are, because any reduction or change in prices has the capacity of wreaking havoc on such a market. Therefore, in the instant case, the council seeks to compare the same to the frozen meat product industry, which is still a nascent industry as has been established in paragraphs 1 and 2 of the Moot proposition. It's still a nascent industry economy, and therefore it is still in the process of developing, and therefore such price parallelism in the early stages is not out of the ordinary.
Do you have any judgments of this court that supports what you say, or of the CCI that says something similar?
Honorable Member, with respect to price parallelism, there is the council seeks to place reliance on the Rajasthan cylinders case, which seeks to highlight how price parallelism alone is insufficient to establish a violation of the Act, and the council applied the.
But Rajasthan cylinder, which often you both are quoting, is very distinguishable because plus factors are here, some email exchanges happen, meeting also. So how can you compare and maybe take advantage of that judgment passed by Honorable Supreme?
Why should projected prices not be plus factors?
Yes.
And therefore, coming back, what do you think are plus factors that one have to look at to assess if they're met?
If the council may have a minute to collect.
Sure.
All these factors.
That's okay, council, you can answer that.
I mean,
We collected the evidence.
the council addressed that.
I think we have heard, I think. Rebuttal.
Answering in the rebuttal.
If the council addressed it now,
Thank you.
please.
Why don't we give them a minute? Let them respond.
Much obliged. Firstly, so parallelism plus criteria has not been met in the instant case. As firstly, the email exchanges did not take place between the companies. They took place between the company, each individual company and Kappa. Therefore, there's nothing indicating coordination in the same, as is already been established by the Good Council. Secondly, Honorable Members, addressing the point about projected prices, there is nothing in the paragraphs preceding in Extra 2 that indicate that these are prices that have been agreed upon. Honorable Members, the Council seeks to highlight how projected prices could also be a response to inflation. It is wrong to base such findings on mere conjecture that these are the result of collusion, since the projected prices do not involve such large variations.
What is the percentage increase for alpha versus beta versus gamma insofar as frozen sausage?
Honorable Member, may the Council address this question in the rebuttals once they are.
Just consider that and come back. Show us that there is a difference in percentage.
Indeed, Honorable. If the may the Council proceed with the prayer, or shall I-
That's all right.
It was a pleasure having you.
Greetings to the honorable bench and me.
Just give 30 seconds.
Greetings to the honorable bench and meet this distinguished. The council appearing on behalf of the respondents in the matter council's permission to address the question electrically as aided by the learned researcher, the council would be dealing with the first issue and would take 18 minutes of this precious time. Following which, my co-counsel would be dealing with the next two issues and would take 23 minutes. Additionally, in reserve 4 minutes for Salvador.
So why should we hear a authority which has passed an order? Supreme Court has consistently said that the authority passes an order and becomes unreasonable. Should the CCI be any different? Why should you defend your order? I can understand an informant coming forth. Why should we hear the authority? It's like every trial court judge or every single judge will come and appear and defend the order.
Your Lordship, to answer that question, it is submitted on part of the council that in the present case, since the appellants have approached the Honorable Tribunal Section 53 of the Act, and CCI has been formed a party in the present case, which is why it is required for the CCI to.
I will make the President of India a respondent in a petition tomorrow. The President of India come and say, notwithstanding the protection under the Constitution, I will come and defend myself. What does the Supreme Court say about the Competition Commission's ability to participate as a party?
You aware about any case law on this subject, which my learned brother is asking to you? Why CCI is before us? Why you are defending your decision?
Lordship, the council is not aware of a specific case law. However, there are cases in which the CCI, has also, in which the councils have also argued on behalf of the CCI, which was in cases like alleged cartelization and single manufacturers. Lordships, in that particular case, the case was before MCLAT and the party was CCI was much on late.
Just because it has happened previously, right? You're wrong. That does not mean it was correct.
Lordships, to answer that question, the council highlighted the said precedent because the council wasn't aware of any specific Supreme Court judgment. Lordships, the first issue before this Honorable Tribunal.
As what he said. So what he has to do. And soon of the case will be considered as necessary. Other cases for very cautious while
See, I have one question for you. Have you prepared the case based on the findings, or are you arguing on the basis of what they have argued?
The issues which have been framed by the Honorable Tribunal itself, the council will be submitting, addressing the same in the present case.
My question is, for the last 18 minutes, you have heard their submissions. Are you per contra making submissions to their submissions, or are you just arguing on the basis of the findings? You are a respondent counsel, right? You would eventually support the order of the CCI. So you have to argue on what their submissions were, whether they are tenable or not. Don't argue on what you have prepared. So did you make a note of all their submissions? What are their submissions?
Lordships, first, the submissions regarding the first issue were that first there did not exist an agreement among the companies, and second that it did not cause any appreciable adverse effect on the company. And your Lordships, to answer the same, I shall my answer to the same is an affirmative for the first issue that indeed there existed an anti-competitive agreement among the companies, and I shall substantiate the same in a twofold manner. Firstly, that there existed an agreement among the companies, and secondly, the same agreement is likely to cause an appreciable adverse effect on competition in the market.
This is the agreement.
Lordships, to highlight that, if I may draw the attention of the Honorable Tribunal towards Section 2B of the Inter-Competition Act, which defines the term agreement. Lordships, Section 2B mentions the phrase any arrangement or understanding in concern. And your Lordships, when the usage of word any in itself suggests that the definition is an inclusive definition which suggests that agreements need not be formal in nature, and parties can enter into such agreements by gestures as well as by gestures such as a nod or a wink. Additionally, your Lordships, if you may refer to the case of Rajasthan Cylinders and Containers.
Yes.
I will proceed. Your Lordships, if you may refer to the case of Rajasthan Cylinders and Containers Limited versus Case of India. On page 2 of the compendium, Lordships, in that particular case, the Supreme Court had held that where an agreement falls under the ambit of Section 3.3, it is presumed to have an appreciable adverse effect on competition.
So why don't you identify the agreement from the record? What is the agreement?
Lordships, the council would like to draw the attention of the tribunal towards Annexure 2 of the Lordships. Annexure 2 of the Lordships. Lordship, the essential two of the proposition is the strategy document which was obtained from head offices of Delta Enterprises during the DG's investigation. Lordship, if you may refer to the very first sentence of the said annexure, it mentions that it was a collaborative effort which involved government as well. Now, Lordship, if I may point towards clarification of 42 of the as provided, it mentions that government did not have any policy or regulation with relation to pricing in the sector, which is why Lordship, proceeding further, the strategy document obtained from offices of Delta it consists of pricing information shared by the applicants among themselves, which not only includes historical prices but also projected prices for the commodity.
So these are estimated prices, may or may not happen. I can write down 300 as opposed to 250. What does that matter? Have these prices actually been acted on? We don't know. Then
So first, simply to the second paragraph, consolidates pricing structures.
and industry. So industry, I know what it is selling for today. Applying a figure, they tell what it will sell for 2 years later.
Lordships, to answer that question, since the word mentioned here is projected prices.
So you have to understand one thing. We keep on asking you many questions. These are all perishable products, subject to discounts. Suppose there is a festival now, Ramzan. Price goes up and come down. Based on the data what you have given, can just conclude saying that this is all accepted or created or they have sat and decided the prices for the entire year. It cannot be. These are the days of seasonal sales.
Answer that question. First of all, the council would like to refer to para second of the set background of Annexure 2 itself. Indeed, it mentions that this report consolidates pricing structures and industry insights. However, your lordships, the second sentence mentions that by fostering synergies between industry leaders, we seek to create a more efficient pricing framework. Now, your lordship, the very fact that the applicants themselves have considered and they have collectively prepared this table and projected and have prepared this table by mentioning the projected prices. Furthermore, your lordships, in para 1, there is a claim part of the applicants that it was after meetings with regulatory authorities. My lordships, who are the regulatory authorities in the present case? Is it the CCI? Indeed, not your lordship, because there is nowhere mentions that the regulatory authorities were involved in setting prices of the products.
And sorry, just one question. You take us to para 2 where you say that we seek to create a more efficient pricing framework. This is on Delta's letterhead. There's no other indication that alpha, beta, gamma collectively sat with Delta to this. How are you inferring that all of this was collectively done? Is there any proof to that effect here?
Lordships, to answer that question, even though it is on the letterhead part of Delta, however, first of all, if I may humbly submit that the clarification itself mentioned that the validity of the document need not to be argued. However, even if we assume that it was on the letterhead part of Delta, however, the prices which were exchanged in the present case comprises of all the 5 companies.
Okay.
This could not have been happened without a communication.
Maybe letterhead could be stolen or maybe somebody can misuse letterhead. So do you think that still maybe letterhead is something very sacrosanct?
And you also
sold in the retail market, the prices are known.
correct, because it says industry insights. So there may be a third party report that may have given them current numbers and they may have used a formula to give projected numbers. Do you think there's need for us to necessarily observe that it was collectively made by all the 4 or 5 people and that these were absolute numbers that were exchanged? Or maybe industry reports and market information was used to prepare this?
Humbly understands the concern of the opponent. And to answer that question, I would like to again reiterate my submission, which is regarding the very claim in the present document, which mentions that we seek to create. My lordships, the very fact that the applicants have admitted that they have seek to create this table and pricing framework in itself establishes that there was certain communication part of the applicants. Another contention part of the council is, if you may refer, if the lordships may refer to page 6 of the compendium, para 83.
6.
Not the same page. Lordship, it is the case of Rajasthan Cylinders, in which the Honorable Supreme Court has held that a conduct evidence is the single most important economic evidence, and it includes parallel pricing, which is changes in prices by rivals that are identical. Now, Your Lordship,
Can you actually take us to where this is absolutely parallel and identical in the table that you've been showing us?
Your Lordship, indeed, Your Lordship, if you may refer to last page of the compendium, wherein the council has taken the effort to bifurcate the percentage increases in the prices of products. Your Lordship, it mentions the identical percentage increases in the prices of products, and even if you refer to the last column, which is prices for the year of 2024 to 2025. Lordship, the final price of the products are essentially same. If you Lordship,
Sorry, can you just take us back to
the last page of the compendium,
348?
50, Your Lordship. Lordship, the council has taken the effort to illustrate the percentage increases. My Lordships, if you may refer to the increase in percentage, they are essentially similar across all the products. And furthermore, Your Lordships,
Don't they range from a -4 to a plus 4.9?
Your Lordships, however, these percentage increases are for separate products as I mentioned.
And in any case, you're looking at projections for 23, 24, 24, 25. You're not doing a projection from or showing a percentage increase from the start to finish. So you're looking at two columns, and then there's still a range of about a 10%.
Council apologizes that the same hasn't been done present. However, if you may refer to the final prices of the products which were mentioned in the year 2024 to 2025, the prices of the products are essentially similar across all the 5 companies, which in itself establishes that the companies had colluded among themselves and there was a clear meeting of minds on part of the companies. Furthermore,
See, if you see MRP on any product, it will be almost same. Have you stated anyway what is the maximum retail price?
To answer that question, indeed, if we see MRP on any of the products, it would have been same. However, the same would be justifiable if it would have been based on independent decisions and market conditions. However, in the present case, the same is based on collusion among the companies.
No. See, suppose MRP is 272. That's a maximum retail price. Someone is giving you for 271, somebody is giving for 270. You say that there is an understanding. Can't be. Because that's the maximum price fixed by the authorities. This is the price at which, considering the tax, GST and the local other taxes, considering all that, that's the maximum price fixed. Suppose if the price is same offered by 5 companies, are you saying that there is an understanding among the 5 companies?
So that question. First of all, regarding the MRP question, Lordships, here this is not the MRP of the product because the companies operate in the B2B sector and not B2C sector. And furthermore, if I may, regarding the correlation in the prices, if I may draw the tribunal's attention. Towards the case of towards the page 78 of the compendium, Lordships, in this on the same page, in the case of unrelated cartelization and cement manufacturer, para 111. Para 111 talks about correlation coefficient.
Yes, what is that concept?
Yeah, I've always struggled to understand.
Lordships, it is a statistical tool to ascertain the degree of linear association in 2 variables, and the coefficient of correlation ranges between -1 and +1 and provides the direction and strength of the linear association between 2 variables. And your Lordships,
You want to explain that to us? We've read this, but explain how that works and if we need to.
Lordships, if you may refer to page number.
Tell us concept.
Tell us how it works.
What is the idea?
+1 indicate if the correlation coefficient, the value of correlation coefficient is near to +1, it indicates an alignment or correlation among the companies. And if it is near to negative, -1, it indicates that there is not a correlation. And the same has been prepared by the council on page 347 of the company. Your Lordships, the same page.
What does it indicate in terms of percentage?
Your Lordships, the correlation coefficient in the present case is 0.98, which was also in the case of cement, in related cement cartelization, and it was held that it was, which in itself established that the prices were in itself correlated among the companies. Proceeding with the second line of my argument, Your Lordship, it is humbly submitted that the appellants have failed to rebut the presumption of appreciable adverse effect, as the agreement is a clear violation of 19B, as it causes harm to consumer goods. Your Lordship, the very preamble of the Infra Competition Act in itself mentions that preserving consumer interest is one of the primary objectives of Infra Competition Act. And the same would have been preserved in the present case if the market is adequately regulated and all the possibilities of AEC are being eliminated from the market, and consumers get an opportunity to make reasoned choices as per the prices.
What is the preamble of the Competition Act? Can you tell us without looking at?
The council doesn't remember verbatim. However, the preamble states that the Competition Act seeks to protect the competition in the market by creating seeks to protect competition in the market among the companies, as well as to preserve consumer interests.
Keeping in view the economic development of the country.
Indeed, Lordship.
2023, where is the need to do all of this? What stage of development are you? Are you a developed nation? Are you a developing nation? And is it not better for consumers to have free play? You have 5 large players, they compete with each other. And the possibility, as counsel for the appellant says, that any modification in prices will attract customers to the other side. All they had to do was to allow free play. That's an argument in your favor, by the way.
Proceed. That question, council would like to humbly submit that free play could have been however, since in the present regime under the Competition Act, the Section 33A itself bars the companies to collude among themselves to set prices, which is why in the present case the action of the companies is anti-competitive in nature. And furthermore, Your Lordships, I see that my time is running out. I would like to just put a last submission before the honorable bench, which is that the company's collusion creates entry barriers for similar entities like Kappa, who are not able to deal at the prices set by the manufacturers. And Your Lordships, as the manufacturers have outrightly rejected to sell their products below the existing retail rates without citing any justifiable reasons, it is a clear violation of Section 19(3)(a). And if I may draw the tribunal's attention towards the case of CCI versus artists and technicians of West Bengal Film and Television, Your Lordships, on page 13 of the compendium, Your Lordships, the facts and the judgment of the case clearly mentioned by the Honorable Supreme Court that the prohibition of exhibition of serial or television prevented competing parties in pursuing the commercial activities, and protection in the name of language goes against the interest of competition, depriving the consumers of their choice, and acts of coordination committee cause harm to consumers by depriving them from watching the dubbed TV serial. It also hindered competition in the market by barring the serials from exhibition on TV channels in state of West Bengal. And
So how this judgment will be helpful to you in this particular case while defending your decision?
The council is trying to draw parallel set judgments by essentially the conduct of the party, the conduct of the appellants in the present case, by colluding among themselves and being reluctant in lowering the prices which have been set by them, and creating strategic barriers to entry for entities like Kappa into the market. That answers your Lordship's question. I would like to invite my co-counsel to address the next two issues. It was indeed an honor for the honor. Thank you.
During the moot court competition, maybe you can take all these formalities, but when you are going in actual courts, there is no requirement to ask all this. You can directly come, maybe address us. So this is just for your benefit, I am telling you. And in the course of time, you are going to learn all these practices.
In the matter and commission, I shall be addressing issue number 2 and issue number 3. And if your lordships have no preliminary queries, the council seeks permission to address the second issue. Your lordships, the
Just
second.
in 1 minute, tell us the facts on which you are arguing. Just in 1 minute. What is the fact issue? We will discuss later.
Well, then,
Only on this second and third main issue, what are the facts percolate to ultimately leading to those 2 and third issue?
lordships may refer to para. Your lordships para 14 not to believe that Mr. Alpha's head of marketing sales had access to Gamma's profit margin data for structure during the due diligence. That is the acquisition of Gamma by Alpha. Furthermore, lordships, para 15 goes on to highlight the findings of the Director General with regards to the same, and he eventually concluded that the information exchange between Alpha and Gamma was completely sensitive and would negatively influence market dynamics. Your lordships having
Please continue.
much of pleasure, lordships. Your lordships, the title submission of the second issue is in the affirmative that indeed there did exist an anti-competitive agreement between Alpha and Gamma under Section 3 of the Act, separate to the alleged anti-competitive agreement between the companies. Your lordships, I shall now proceed to
There was a
demonstrate.
cartel within a cartel.
Your lordships,
There was a cartel within a cartel. There's already a cartel amongst 5 people. Now you're saying there are 2 between them who are merging. There's a cartel between them.
Or are you suggesting that this is in the alternative? Assuming that there is no cartel, then there is at least a sub-cartel.
lordships, the submission of the council with regards to say that there indeed is a cartel amongst the 5 competitors and there is another cartel amongst Alpha and Gamma. Your
Just
lordships,
wondering, why would I need to do a sub-cartel when I'm already part of a larger cartel?
your lordships, the same is necessary because when we consider the nature of information that has been exchanged between these 2 entities, they're claiming that it has been exchanged in the process of an acquisition. However, your lordships, considering that the information pertains to profit margin data and cost structures, and considering that it is comparatively sensitive, there were certain safeguards which must have been employed by these entities. And since these safeguards have not been employed, neither the exchange of this comparatively sensitive information amounts to contravention of Section 3(3)A of lordships.
And what safeguards,
Sorry.
go ahead. What safeguards are we talking of over here?
Your lordships, if I proceed to the first limb of my argument, your lordships, the first limb of my argument is that the exchange of comparatively sensitive information between these 2 entities is during the due diligence process without any safeguards. And your lordship, to submit on the same, it's a certain leverage that parties in a merger and acquisition transaction have when it comes to exchanging information. However, considering that the nature of this information is price sensitive, there are certain safeguards. If the honorable tribunal be pleased to refer to page number 2.
Why don't you just tell us about it?
Just the complainant said which the page referred is the compliance manual by the Competition Commission 2017, and it goes on to state that profit margins and cost structure data is indeed comparatively sensitive, and during the due diligence process, such data must not be shared. Furthermore, it also goes on to state that forward-looking plans must not be shared. And if we speak about the applicability of the same in the present case, it paramotorically beyond doubt that I said the question, Your Lordship.
So is partially maybe, is there a way you can still share this information and be compliant under law, or there is no way that you can share?
There are ways to share such information without violating the law. That if you see it with my refer to the flag 15 pending on behalf of respondents. Such a flag 15, page number 216, essentially highlights whenever entities engaged in such a transaction are exchanging information, they must involve the formation of clean teams. And such clean teams must not involve individuals who are engaged in sales, marketing, and pricing. And if we look at the designation of Mr. Nehru Navarro in the present case, it also is beyond doubt that he was not qualified to exchange this information. And considering his involvement, the information is not ring fenced in the present case because it is being exchanged from the head of marketing sales of one enterprise to the head of marketing.
And why are we inferring that he had not abstained from taking part in his day-to-day job while he was discussing all of this? Is that okay, or he still couldn't have exchanged information?
This right the manual again serves as an important indicator. The manual goes on to state that the reason behind not employing such personnel who are engaged in sales, marketing, and pricing in such transactions because so that they do not unconsciously.
Agreed, Counsel. Are we saying that sales marketing personnel can never be on field teams? Or is there a way that they can be if they, for example, abstain from their day jobs for 3 months prior and post?
Such as the submission to the council that the market person not being a part. And for that,
I'm having one question to you, just general, I would like to know from you. Whether Competition Commission of India, whom you are representing before us, has any power to pass interim orders? If yes, under which provision?
Honorable Competition Commission indeed has the power under Section 33 of the Act to pass interim orders.
And at which stage and what are the factors to be considered?
Your Lordships, when the interim order can be passed, I will refer to the
The factors are not there.
Factors have not been given in Section 33.
Question is on the factor which you.
Your Lordship, the council is only seeking assistance to answer regarding the stage when such order may be passed. Your Lordship, as per the language employed in Section 33, where during the inquiry, the Commission is satisfied that an act contravention of subsection 1 of Section 3 or subsection 1 of has been, and as it follows, your Lordship, has been committed and continues to be committed, or that such act is about to be committed, the Commission may, by order, temporarily restrain any parties from carrying on such act until the conclusion of the inquiry or until.
So factors has not been given, so you don't know the factors. Secondly, whether before forming a prima facie view under 26(1) or after forming a prima facie view, this interim protection or order can be granted by the CCI.
Your Lordship, when we speak, whenever an information is filed under Section 19.
Are you aware about any parallels in CPC about passing interim injunctions?
Your Lordship, at the present moment, unable to recall the.
No problem. Continue with your argument.
Your Lordship, if I may answer the question regarding the stage at which the interim order is issued. Your Lordship, once an information has been filed under Section 91A, the Commission takes time to form its opinion. And then during that period, the Commission can also conduct a preliminary inquiry, in which it also can hold a preliminary conference, and it may seek the other aggrieved party or any.
My pointed question to you, at what stage? Before prima facie or after prima facie? Continue with your answer.
You are relying on the compliance manual, is that binding?
Indeed, the compliance manual is not binding, Your Lordship. Considering under Section 49 of the Act, the Commission has a role of also competition advocacy. Therefore, Your Lordship, the purpose of competition law is not merely to also prevent such action and to enforce a culture of corporate compliance. I would also like to cite to substantiate my.
See, one basic question. You are now making submissions on B, right? B issue B. How will it come into the ambit of Section 3? Suppose you want to acquire a company. Another acquisition means the companies, they want to acquire a company, right? So unless I know what is the cost of the products, what is the pricing pattern, how will I prima facie come to a conclusion it's worth acquiring it? So in that context, what is wrong in sharing information?
The council appreciates the concern that brought to the bench, and indeed, cannot be shared is because, Your Lordship, in the course of ordinary day-to-day activities, no competitor will certainly disclose its profit margin data or cost numbers to any of its competitors. However, as Your Lordship have rightly pointed out, in merger and acquisition transactions, it becomes relevant. But Your Lordship, considering that there may be multiple sham transactions in which one entity may gain access to the information of the other entity, there are certain safeguards which must be employed so that this information is not resulting in action. So the this information is not being acted upon in the day-to-day activities. And that is why lots of the compliance manual and also practices across the jurisdiction of the FTC and the European Commission want to state that the employment of PE is extremely necessary. And with the permission of this order, you can also cite a leading European Commission authority on the same. If your lordship may refer to tab 22 of the compendium, lordship page 323. Lordship, this is the
Whether foreign judgments are binding on us,
lordship foreign judgments are not binding to this order. However, the
what
judgment,
CPC says.
lordship, lordship, I would again like to apologize for my lack of knowledge at the present moment.
What page were you taking us to?
Lordship, page 320. My lord, Your Lordship, this is essentially an extract from the judgment of the European Commission case paragraph 42. Your Lordship, paragraph 53 of the judgment not to highlight that the information exchange between the executives of Aldice and Portugal were without any safeguards in the form of considering that the CFO, that is the Chief Financial Officer, and the Director of Finance were involved with no limitation whatsoever on the time of policy.
The applicant, the respondent on add item on citing one precedent. Okay. Both of you are citing the same precedent. If you add item on that this precedent applies.
Your Lordship, it is my commission that the said that the supposed answer responding, Your Lordship, and there was another question.
How will you distinguish what they are from this precedent?
Your Lordship, if I may just see 10 seconds to answer the same.
Because they argue that it's a free term.
Up to para 92 at 320.
Your Lordship,
Paragraph 92. Section 91 and 9.
Related concept.
Tell us if that's the distinction.
Your Lordship, constantly understands what Your Lordship directing the act and to select that when we consider the kind of information and kind of influence that Aldice presently sought to direct over the day-to-day operations of this enterprise, in light of this, the Commission noted, that decisions on licensing for funding are commercial policy and the unfettered ability to set prices. This is something that I would seek Commission to address, especially since the same deals with the proposed exchange of information.
Then that also company should be and address it right away.
Your Lordship, I understand the.
So your time you decide.
Your Lordship, in the interest of justice and considering from para 17 of the proposition that the case has garnered national attention, raising important questions about the scope of competition law enforcement and the admissibility of evidence across investigation and market dynamics. It indeed becomes relevant for the Council to also address the second prong in Substantive and also the second violation which has been blatantly committed by the offender. Your Lordship, as I was highlighting, in the case of Aldice, one of the factors that played in the final judgment of the Commission that there was no limitation as to which regarding the information to be exchanged. In this light, Your Lordship, I direct the Honorable Tribunal, Annexure 3.
Well,
Your Lordship, para 2 of the annexure goes on to highlight, and if I may continue, Mr. Dev, we believe that damage commission as market people, we and prove that transaction. Your Lordship, when information is being shared across users, it has to be strictly limited to that purpose. And this is something which has also been supported CAD guidelines which have been passed by the Administrative Council for Economic Defense Brazil. Your Lordship, while I understand the same are not binding to this honorable tribunal, however, the Commission has also referred these guidelines in the case of Bharti Airtel and Newstal Kodas, and therefore the Council seeks to place a persuasive reliance on the same. Your Lordship, goes on to highlight. You can also find the same on page 130 of the compendium. Information requested by the key employees has to be restricted to what is strictly necessary for the purpose. And if we look at the language employed in the action, it clearly goes on to reveal that this was also, the information was also intended to be utilized to free the transaction, to enhance the position. With that, Your Lordship, there is like unauthorized.
Doesn't para 3 in fact take your argument forward?
Your Lordship.
Mr. Navarro's letter, because it seems to suggest that he understands the sensitivity of detailed margin data. He says it would be helpful to receive broad insight and aggregated ranges that can provide directional clarity.
Not asking absolute errors.
Lordships, there has to be, Lordships, in order to answer that question, indeed, broad or aggregated ranges can play a significant role in reducing the granularity or the sensitivity issue associated with the data. However, Lordships, the very fact that Mr. Navarro is seeking that data defeats the purpose of the very first place. The company claims that it has employed all the compliance protocols, Your Lordships, although that's mere rhetoric. Because considering the engagement of Mr. Navarro, it is the purpose stands defeated, Your Lordships. Also, there was another very important thing highlighted by the council for the appellants regarding the to be shredded aspect of it. And I would like to bring this honorable commission's highlight that, Lordships, if we refer to section 41 clause 3, subclause 3, it goes on to highlight, and if I may read for the bench's convenience.
Also, but that would be applicable in the source of an investigation. What you are but read it.
Your Lordships, if I may read for the bench's convenience. Apologies for the disruption. Your Lordship, it goes on to state that without prejudice to subsection 2, it shall be the duty of all officers and other employees and agents of the party which are under investigation to preserve and produce all information.
Yes. Was this added also?
Your
When was this added? 41.3.
Lordship, 41 Act was added by the Act 9 of 2020, and it came to force on the 18th of May 2020.
And when was the raid council?
Your Lordship, to answer the same question. Your Lordship, when the Commission passed an order on the when the Commission passed a prima facie order on the 24th of April 2022, in that order, it directed the DG to conduct an investigation, and it was pursuant to this investigation that the DG requisitioned for some information, and it was revealed during the day that certain documents were found to be shredded. Your Lordship, it is
So they were not shredded council.
Not to be shredded.
That's a difference.
Your Lordship,
I may call a document to be confidential or to be shredded. But how do you attribute intent to that?
Your Lordship, considering that parents have brought this fact before this honorable commission to suggest that the same is a common business practice, it also would be important. It would be important for the CCI to highlight this. It can also highlight the potential tampering with the evidence. And it is in this light that I would request the honorable to take note of this. With that, Your Lordship, I proceed to the third issue at hand. Your Lordship, the third issue that practice for consideration is whether the information under the Act, under the term sheet, has albeit comes violation of the Act. Your Lordship, the submission to the same line affirmated that indeed it is in fact in violation of the Act. Your Lordship, as for the clarification, the transaction is a notifiable transaction. Furthermore, considering the valuation of this transaction, that was 3,500 crores, it was indeed the duty of the parties to notify to the commission. However, it was considering
It's not time limit council. They're not, they can notify at any point.
Your Lordship, the council indeed acknowledges the 2017 government notification and followed by a 2020 notification which eliminated the 30-day filing requirement and the recent 2023 amendment which essentially indicated that before the consummation, the parties are free to file the notice.
Yes.
However, Lordship, one very important observation arises in the case of Ultratech Cement, wherein the Commission highlighted that standstill obligations arise. Standstill obligations, which are essentially that parties must continue to compete for the combination is approved for any adverse effect on the competition. Lordship, the judgment was ordered to politics. Lordship, order goes on to highlight that before the filing of the notice, even during that period, parties have to adhere to the standstill obligations. Because Your Lordship, Otherwise, the parties would just take the plea that this act of negotiations and commercial policies or matters that was before the filing of the notification. Therefore, it is not in contravention of Section 62.
That precedent is 2014 council. That is still applicable to the 2017 and 22. The 20-day requirement was there. At the time, the Ultratech precedent was there. Fact that you are referring to 2017 and 22, does that take away from this precedent's value?
Your Lordships, it indeed does not take away from the precedent's value, actually, because in the context of a period where the 30-day limit was applicable, the parties might see that since the 30 days period is still present for the parties who file a notification, therefore any kind of negotiation is permissible. However, the negotiation in itself amounts to part conservation. The same gets attached to scrutiny of
Procedure.
in this context. I would like to
There are a couple of minutes councils. What's your word?
noted your Lordships. Also, it also becomes relevant at the present juncture to look at term sheet, your Lordships. Your Lordships, the term sheet is essentially encapsulated in para 30 of the Moot proposition. And if you are Lordships will be pleased to look at clause B of the term sheet, it states that alpha may provide pricing strategies for geographical allocation closer to the consummation. Your Lordships, consummation was set to happen in 2025. Therefore, closer to the consummation essentially means essentially indicates a period where the transaction has not been notified. Therefore, the parties were supposed to maintain certain standstill obligations in this
But
context.
council, that's why it says may provided. What is the evidence to suggest that it actually did?
The present case that indeed concedes to the fact that inputs have been provided. Because your Lordship, the language of the issue itself indicates whether the proposed exchange of information. However, considering that the term sheet was executed 1st of April 2024, that in itself indicates that Alpha had reserved the right for itself to give inputs. And your Lordship, considering that this was before the commission has reviewed against the ex ante nature of the review process, of combination. Another leading authority of state, the judgment of Adani wherein the commission is contained by the acquirer finding. However, in this regard, the commission observed, and if I may also refer to comparative applications. The Lordship, if I may, apologies for the interview. Lordships, if Lordship, the council is able to remember the page number, so if I may just take a moment to correct
You're looking for council.
Lordship, the exact paragraph.
Adani.
Yes. Lordship, page number 233.
Yes.
To travel to page number 6.
Yes.
And if I may speak,
Certainly.
Your Lordship, there are certain combination distorting effects which have been laid out in the padding para number 28 29 of the said order, Your Lordship. And it goes on to highlight certain potential competition distortions, which go on to state first that acquirer gaining strategic advantage, reducing the incentive and will of the target to compete, and also reasonable ways to access the confidential information to target, creating situations similar to tacit collusion. Your Lordship, if Alpha exercises its right to give inputs, it would also be seeking certain information from the target. And this certainly has the potential to result on all of these factors, Your Lordship.
You want to conclude council?
Your Lordship, I would certainly like to, however, considering that this is a very important term, geographical allocation mentioned in the term sheet, it also becomes relevant to point out the authority on tab 21 on page number 313. Lordship, para 8.8 of the judgment of April goes on to highlight the term. The clause which allowed for the seller to put restrictions on the entry and exit of the target, that's essentially held to be held as amounted to gun jumping.
And how is this relevant for our case?
Your Lordship,
How is this relevant for us? How is LT Foods relevant for us?
Your Lordship, the judgment of LT Food is relevant in the present case also allows system directive itself to give certain inputs to the geographical allocation of the entity gamma. Also, before I conclude the submission, I would like to reiterate and refer the preamble of the actual objects.
Very well, counsel. Understood. Thank you.
The objects the same, if I may proceed with the prayer.
We have your prayer.
We have your prayer.
Thank you. Are you ready with your rebuttal, counsel?
It is indeed an honor arguing to be exalted.
May the council begin?
Just consider if your third member would like to maybe give rebuttal or sir rebuttal, just for your convenience. We have already tested two of you. Researchers, okay, research, oh, perfect.
Which have been raised. Delegate and delegated to the department. Firstly, the council would apologize for not recording the exact paragraph. It is paragraph 26 of Ordinance 3, which particularly refers to the AAC as a threshold for evaluating.
Sure. Can you take us to that paragraph? What page, counsel?
I just wanted to check the question which I posed to you on the other side. What are the factors when court, be it High Court, Supreme Court or Civil Court, while considering to pass interim order, what are the factors to be considered?
So in the case of exigencies, in the opinion of the court or the forum, where in the opinion of the forum, it is essential to impose such a standstill obligation if the company competition at relevant terms in order to prevent a further violation or a further law, while it seeks to evaluate the case further on its merits as well as.
Prima facie is there. Prima facie existence of prima facie case has to be there.
Honorable member, it's not an essential.
Not essential.
It's not an essential facet, however, it varies from case to case. However, it remains that.
Order 39.
Order 39 of the CPC. Are you aware of the threefold test?
Threefold test, yeah. I was just indicating about that only because when you are looking to argue whether a corporate law matter or any competition law matter, you should be well versed with CPC.
Does the Supreme Court address the contours of 33 in any judgment? Yeah. Has the Supreme Court addressed section 33 in its contours? What do they say?
Remember that due process
The context of interim review.
We sought interim review for the procedural violations of.
Now they are going in due.
That's
Just what is due process difficult.
Honorable members, the council shall take.
Para 38, counsel.
Rani.
Para 38.
26.
26 page number, black 2. Para 26.
If the council may read it out.
Yes, please.
Considering the mandate of the act in terms of preventing any likelihood of an AC, the question of when a combination can be said to come into effect also needs to be considered in the same spirit. And it is in this context that the council seeks to redirect the honorable members to
Understood, counsel.
a much better honorable members. And the AC has been established in the written submissions, although the council could not address the written submissions. However, addressing the next point, actually, there's apologies for exceeding time.
That's
May the council address this as well as the next few slides. Honorable members, the second question raised to the applicants is the percentage increase and the range calculated from a very rudimentary from the financial year of 2021 to 2024 is a range of 11% to 13%. However, honorable members, that's be attributable to inflation as well, and therefore there's nothing that indicates that it is the outcome of a collusive or a price fixing agreement. The council should now seek to address the rebuttals in reverse order of issues. Firstly, the council. However, the council for the applicant seeks to highlight that the term sheet does not mention any specifics, as has been mentioned in the calculations. The clauses of a contract are to be read clearly without supposing any extraneous meaning. The term sheet and 13B in particular, he mentions geographical allocation. Geographical allocation is only a violation of the Act when it is geographical allocation of markets or sources of production. There is nothing in the conduct or in the agreement or in the part of the agreement that indicates anything pertaining to the same. Second, honorable members, the council shall also seek to highlight the erroneous submissions made by the learned counsel for the applicants, as the order continues to remain under section 27. Therefore, the council fails to understand how a violation of section 62 and 62A has been brought up in treating the honorable appellate tribunal as a court of first instance. Finally, honorable members, parties are adhering to the provisions and the statutory obligations prescribed under section 62 and 62A of the Act, as there is no substantive or procedural violation. If the council may address the final two rebuttals,
Sure.
honorable members, the heavy reliance on the cement cartel case, while might be certain instances, in the light of the current factual matrix, does not withstand the scrutiny of the Competition Act, as the current factual matrix lacks the presence of the CMA. The presence of the CMA was an integral factor in finding the cement companies violative of Section 3 of the Act. Next, honorable members, the class factors have been completely disregarded by the learned counsel for the applicants. Firstly, this amounts to communication as well as economic evidence. From the lens of communication evidence, the non-zone plan as well as the emails clearly stipulate that it's a collaborative effort among all stakeholders and it's an independent business decision to reject Kappa's offer. Addressing the economic aspect of the rules. Structurally, the council as well as the co-council have established the relevant market structure and how it's conducive to parallel pricing. And secondly, with respect to the conduct evidence, this has been done in under the aegis of the government. Honorable members, council seeks to conclude by highlighting the Office versus Portugal case, which was, as correctly observed by the honorable members, did pertain to a veto power exercised by the acquirer over the target, and this is in the sense of veto powers over the appointment of key business and managerial personnel, which has nothing to do with the factual matrix present before the honorable appellate tribunal today. Therefore, honorable members, councils seek to highlight how the order is erroneous on multiple.
Thank you.
Much obliged, honorable members.
Just to submit on the issue of the section that the order considering that the CCI has passed an order under section 87 and as to how the respondent is breaking the claim under section 62 for that matter. Because I would like to submit to page 9 of the proposition, which is point number C of paragraph 18. The councils are required to address the issues that are to specifically mention some issues and make other arguments under the jurisdiction. Such as their which is not in under convention laws. I would also like to highlight how the reliance of the learned counsel for the appellants from the case of Rajasthan cylinders, how the same is erroneous. Because the reason that the appellants Rajasthan cylinders are not guilty is because a lot of that case the present conditions was that oligopoly market, and because there were only two buyers, and in the present case, indication that there were two buyers, the situation does not pertain to oligopoly for that matter. Further, my lordships, it also becomes relevant to draw attention to the guideline. Lordships, the learned counsel for the appellants have essentially cherry-picked to rely on the efficiency gains arguments. However, it also refer to guideline number 372, must be, it has been stated that undertakings participating in exchanges provided for by a regulation must therefore not share comparatively sensitive information, and wherever possible, aggregated information on ranges should be used. And this also finds support in the NASLAR's ruling in the case of Ambuja Cement, wherein essentially under the Trade Association CMA, the parties exchanged comparatively sensitive information alleging that the same was supposed to be submitted to the Department for Protection and Promotion of the Industry. And this also finds support in the beer cartel case, wherein the parties could ask for discounts. However, they coordinated amongst each other in the WhatsApp groups to ask for such discounts.
Last point.
Your Russians, with that, I conclude my rebuttal, and I would also like to submit that there's a very famous saying in the antitrust circles that the purpose of competition law is to protect the competition and not the competitors' interests. And with that, you'll also get explain.
You guys leave the room for the moment.
No, right.
Thank you.
Thank you.
Thank you.
Usually they give some another room where maybe we can go and.
We can actually walk to another room.
Yeah, walk to another room, because this is, I think, they have some continuous process. Okay. Give some another room.
Thank you.
Yeah.
Thank you.